Assalamualaikum, sir.
Walaikum Assalam. How are you, Sultan Sahib?
Alhamdulillah, fine, sir. How are you, sir?
Fine, brother.
Sir, how is your health?
It's fine.
Yeah, sir.
Good morning, sir.
Good morning, ma'am. How are you?
I'm good. How is your health, sir?
Fine.
Sir, did you see that 2 or 3 days before India's Supreme Court just dismissed the petition filed to not to send back the Rohingya took shelter in Kashmir?
I could not get you.
Sir, Indian Supreme Court dismissed one petition that which was filed not to send back the refugee who are in refugee in Kashmir.
Not to send.
Not to send back to the Myanmar. But Indian Supreme Court told that Indian government doesn't have any authority over this. So I think Indian government is going to send them back. So isn't it a violation of the doctrine of non-refoulement?
Am I audible to you?
Hello? Yes, sir. Yes, sir.
Okay. So actually, I'm not able to get your voice.
Okay, sir. I think there is some issue. Okay, I will send the mail regarding that.
Sir, good morning, sir.
Yeah. Good morning.
Sir, how are you?
Fine. How are you?
Yeah, me fine too.
After a long time, I'm able to listen your voice.
Yes, sir.
Yeah. Well, Mr. Sultan,
Yes, sir. Yes, sir.
Supreme Court of India actually matter is still sub judice. Final decision has not been pronounced. So the Supreme Court is seized with the matter of refugees' repatriation to their country of origin, and that is Bangladesh. So let us have a full-fledged decision on this particular aspect. And let me be in the position of the full judgment or the full decision, whether it is going to be an interim decision or a final decision. Let us have first the decision from the Honorable Supreme Court of India. Because as of now, the Supreme Court of India simply restrained the government to make or to go for any kind of a deportation, repatriation, or expulsion. So far, the Rohingya refugees are concerned. So we are also waiting how the Supreme Court of India is going to decide this particular matter, number one. And number two, what are the contentions of the government of India on this particular issue? Because government of India also value its relationship with the state of Bangladesh. What kind of an arrangements is likely to be take place or likely to be there between the two nation states, that is India and Bangladesh, that still remains to be seen. Because a lot of verbal assurances have been there on the part of the government of India to the government of Bangladesh with regard to any kind of a repatriation or expulsion or deportation of Rohingya refugees. So that remains to be seen, and thereafter we would be in a better position to appreciate the requirements of the doctrine of non-refoulement and other important international human rights obligations. So we have to see what remains to be done. Now I take you to another important facet of our engagement, and that is statelessness. Statelessness is also of vital importance, and how this idea of statelessness has been dealt with under international law. To what extent this particular idea of statelessness or problem of statelessness has been tackled under international human rights law, under international migration law, under international refugee law. There are certain important instruments which are required to understand the entire gamut of statelessness. We have to consult, my dear friends, general multilateral instruments in the area of international migration law, international human rights law, international refugee law, international maritime law, and immigration legislations as well of various nation states. And as a whole, we have to understand how statelessness has come to stay as a challenge to entire broadly of international law. There are some general multilateral instruments, and these instruments must also be consulted whenever there has to be an answer or whenever we try to find out solutions to the issue of statelessness. Then Convention relative to the protection of civilian persons in time of war, certain important experts, certain important portions of this particular convention becomes very, very important. We have to consult a protocol first, additional to the Geneva Conventions of 1949. 4 Geneva Conventions are there. Then we have to consult a protocol or additional protocol first. Then there is another important convention, and that is Convention on Diplomatic Relations, Convention on Consular Relations, International Covenant on Civil and Political Rights, General Comment on the Position of Aliens under the International Covenant on Civil and Political Rights, General Comment on the Position of Aliens under the International Covenant on Civil and Political Rights of 1986. Then International Convention on the Elimination of All Forms of Discrimination. Then there is another important convention for the elimination of all forms of discrimination against women. Then again, Convention against Torture, Convention on the Rights of Child, an international convention, my dear friends, on the protection of the rights of all migrant workers and members of their families. We should not forget there is another important dimension. So far, international text consultation is concerned in addressing or for addressing the problem of statelessness. Then we should not forget 1930 Convention on certain questions relating to the conflict of nationality laws. Particularly Article 1 of this particular convention becomes very, very relevant in our deliberations. Then Article 15 of the Universal Declaration of Human Rights. And as I have already submitted, we are also having 2 important, highly dedicated international arrangements to deal with the problem of statelessness, that is 1954 UN Convention on Statelessness and 1961 UN Convention on the Reduction of Statelessness. Thereafter, we are supposed to consult protocol relating to a certain case of statelessness, a special protocol concerning statelessness, and convention on the nationality of married women, then again convention on the reduction of cases of multiple nationality, then first additional protocol to the convention on the reduction of cases of multiple nationality, then second protocol amending the convention on the reduction of cases of multiple nationality. And we should not forget, my dear friends, one of the most important, highly mature regional arrangements which has been exclusively designed for the people of Europe, applicable in Europe, that is the European Convention on Nationality. So we should not forget. Now, there are certain important, questions relating to nationality, questions relating to statelessness, and how to address statelessness as an international concern. Then we have to take how to address the cases of statelessness and how can statelessness be avoided, reduced, minimized, or removed. These are the different facets which we have to understand. But before I proceed further, the most fundamental question that comes to my mind is a very basic question, and that is, what is statelessness? My dear friends, statelessness has been addressed in 1954 Convention. Article 1 of 1954 Convention relating to the status of stateless persons defines statelessness, or in other words, let me put it like this: a stateless person is a person who is not considered as a national by any state under the operation of its law. I repeat, as per Article 1 of 1954 Convention, a stateless person is a person who is not considered as a national by any state under the operation of its laws or law. It has also been recognized, my dear friends, by the International Law Commission as a customary international law principle. And further, it has also been referred as de jure statelessness. But why should we worry about statelessness? We have been discussing statelessness, my dear friends, because of certain important reasons. Reasons like that statelessness is detrimental, or it is going to cause a detrimental impact on individual lives and family well-being. Statelessness makes a severe knock-on effect on community stability and international relations. If you examine the relationship between Pakistan and Bangladesh, between India and Bangladesh, and beyond South Asia with other nation states, you will find that the international relations on many occasions have been hostilized. An entire idea of bilateral engagement, multilateral engagement, or unilateral understandings have been hostilized by the issue of statelessness among the nations, between the nations. This has presented and created a very, very hostile situation for diplomacy, for international relations, for international stability, regional peace, and so on and so forth, including human rights. Therefore, it poses a very, very fundamental question, and that is, what are the international community's main aims when there is a question of statelessness? When we are asking these kinds of questions, it means there is a situation where if we are asking questions, asking of question signify the persons of a particular issue. And that requires some kind of a solution. And the solution is in the form of how to avoid statelessness, and at the same time, the issue of protection of international statelessness, or I mean the stateless persons, how to protect them. Stateless persons are non-nationals everywhere. This is a factual situation. It has been, stated by all the political outfits, political establishments, and the ruling establishments in each and every geopolitical entity, that stateless persons are non-nationals. This has entailed consequences for their enjoyment of rights. I mean, a detrimental situation has been created, a hostile environment ensues, and the stateless people are not in a position to access their rights, or their entire range of rights has become subservient to the hostile environment. We are having number of what you call, stateless people at international level. Right now, I'm having data of 2016, 2017, 2018, 2019, and up to the what you call end of 2020. If you take into account how many stateless people are there and what are the numbers of the stateless population at international level, then we do not find the exact data. Because there are certain important institutes who are working in the area of statelessness, including UNHCR, International Organization for Migration, International Statelessness Institute, Human Rights Watch, Amnesty International, because it is having some kind of a cascading impact. The mandate of these organizations, international organizations, are exclusive, but there are certain important data which is going to affect their main data, and that is why they are also collecting incidental data, ancillary data, vicarious data, just to investigate, analyze their main data. That is why we are also having overlapping of data. But there has not been any kind of an organized, systematic, and scientific collection of data on statelessness. UNHCR is having some staggering figures of statelessness at international level. But we find some kind of a systematic or systematization of data collection. So far, the functioning of the International Statelessness Institute is concerned. But cumulatively speaking, there happens to be 10 to 12 million stateless people at international level. And therefore, it becomes necessary, my dear friends, to rely upon this particular data for investigating, understanding the problems of stateless persons. If you take into account the studies which have been released, I mean, the global report that is there in the public domain right now, it has collected as many as 4.2 million stateless population, and this report that has been released either in the month of July 2020 or August 2020, it has covered as many as 76 nation states at a global level. Out of the population of 10 to 12 millions of stateless persons, it has determined that there are only 4.2 million stateless persons. Therefore, my dear friends, these 4.2 million stateless people, as per the new data, and further, UNHCR also concludes that the true extent of statelessness in the world addressed does not take into account the data of each and every country, and majority of the nation states have been reluctant to report statelessness figures in their own countries. But at the same time, we should not forget, my dear friends, since there have been no developments so far, the scale of statelessness is concerned to suggest that there has been a major shift in the aggregate numbers. But the estimate continues to be at least 12 million. That is the rough estimate on the part of the international organizations, including UNHCR. And therefore, if you take into account the recent developments in South Asia, particularly in India or Indian state of Assam, in 2019, there happens to be a real risk that the number will grow as 1.9, my dear friends, million people citizenship has been cast into doubt. This emerging context should not be forgotten when we are talking of statelessness. Because the citizenship registration exercise in the state of Assam has identified as many as 1.9 million people who could not prove their citizenship credentials. And this narrative has also been taken into consideration by the international institutes or international organizations As the situation unfolds or likely to unfold, that would be critical to tracking the impact on the overall global picture of statelessness. In addition to this kind of a situation, we should not forget the Rohingya refugees. Rohingya from Myanmar are still the largest stateless population for whom data has been provided. If you take into account the last year data, that is of 2020, the methodology for reporting on displaced Rohingya has been further what we call amended. And data will be available on Rohingya refugees also, particularly in case of Bangladesh, as well as for India, Indonesia, Malaysia, Thailand, because these countries still produce credible data how much Rohingya refugees happen to be there on their soil. Though there are other important countries where you will find stateless people, they should not forget, because as I have already submitted, that there are as many as 76 nation states who have been reported that they are hosting stateless people. But here, once again, our fundamental question that should be answered. And the question is, my dear friends, who are the stateless? It is a well-established fact, and it is axiomatic from Article 1 of the 1954 United Nations Convention on Statelessness. But we have to divide a stateless persons into two important categorizations. One is de jure stateless, and another one is the de facto stateless. So far, the de jure stateless person is concerned, according to the legislation of any state, whenever we are having any legislation, whenever there happens to be any kind of a legislation enacted by the national parliament or the national legislative establishment, and that defines and recognizes a particular person as a stateless person, or a chunk of population who does not enjoy nationality protection or nationality laws, they have been described under the law as stateless person. But so far, the de facto stateless persons are concerned, they are more loosely defined, but they do not enjoy the rights generally enjoyed by nationals. For example, their country will not grant them a passport or allow them to remain, and they are unable to prove their nationality. That is the problem with these stateless people. Mr. Vikas Kumar has also contributed, and let me attend his observation. And it's a question. As per Mr. Kumar, can we discuss a recent Rohingya deportation case judgment, which in my opinion is a gross misreading of Indian constitution as misunderstanding of international law relating to refugees? You are right. Technically speaking, as per your understanding, it is an order. My dear friend, Mr. Sharma, it is basically a question of interpretation. I will definitely discuss this particular, order of the Honorable Supreme Court of India on refugees. But we should collectively try to revisit this idea of interpretation of the Constitution of India, as well as other important international conventions, instruments, understandings, principles of an international character, and how these have been incorporated and encapsulated within the municipal legal system. I do not believe, prima facie speaking, we should not attribute these kinds of words misreading of Indian Constitution. I failed to understand, Mr. Sharma, to what extent it is going to be a misreading of Indian Constitution on the part of the Honorable Supreme Court of India.
Can I say something, sir?
Yes, please. So I would like to request you, as you have used this particular expression, misreading of Indian Constitution. So I would like to know, along with the rest of the classmates, to what extent and what exactly are the contours of misreading, and what are the points of misreadings? Yeah, please.
Sir, I'm showing the screen here, I think. Is it visible, sir?
Yes, it is very much visible.
So I have in front of myself a judgment order of the Supreme Court.
Yeah.
Here we can read that the court has clearly said that national courts can draw inspiration from international conventions or treaties so long as they are not in conflict with municipal law. So this is one observation. Second is that we cannot comment upon something happening in another country. Sir, the very basic issue in the case was the status of the Rohingyas in Myanmar. And if the Supreme Court will not discuss this issue, then the proper disposal will not be done. So it has just, conveniently disregarded the issue. How can there can be decision of the case if you do not discuss the case? And second, and the most gross violation has happened regarding the golden triangle concept in our constitution. It has clearly said that Article 14 and 21 are available to non-citizens also, but it has said that Article 19(1) is available to just the citizens. But it has forgot that there is a so-called golden triangle concept in which 14, 19, and 21 have to be read together. So in this respect, I say that because there are category of judgments available, specifically, I would say IR Coelho in recent 2007 judgment, which said that these three articles have to be read together. So the Supreme Court, what it is doing, it has interpreted these articles in silos, and that is why I said that this is a misreading of the Constitution. Yes, sir.
Thank you. Any other observation from any other student?
And see, sir, what very cruel type of terminology has been used by the court. In the last para of the order, it says that they shall not be deported unless the procedure prescribed for such deportation is followed. So again, we are moving to the era of A.K. Gopalan and that habeas corpus case in during the emergency era. So it's like forgetting the Menka Gandhi and other leading cases pronounced by the Supreme Court itself. In that regard, this is very primitive judgment, I would say. And the most important thing is that the court has not dealt with the argument of the petitioner itself. It has just said we have seen the contentions and now we opine this. So this is a classic case of non-speaking orders, and that is the violation of natural justice also, because this is the third cardinal principle of the natural justice principle.
It is, my dear friend, the latest Supreme Court, decision or order is not a final outcome. Supreme Court of India, though the deportation has been stopped, but this is my humble submission to all of you. The Supreme Court of India is not an establishment located in some kind of an ivory tower. Supreme Court of India is an institution of a judicial character, and that is also the part of this social milieu. It is an institution that is having and discharging its obligations in a globalized world. Supreme Court of India cannot absolve itself from its international obligations as an institution. Whenever there is a question of preservation of human dignity and human rights, then the Supreme Court of India has to come forward to fill golden silences and golden gaps. Whether we are having some golden triangles of interpretations or not. Question relating to refugees is of vital importance. It is immaterial whether the government of India is privy to a particular international human rights instrument or not. It is the robustness, it is the magnitude and scale which is available at the constitutional pedestal supported by the Constitution of India, and that is sufficient to answer all the international obligations. As a part of the liberal democracy, as a part of the constitutional democracy, as a part of a nation state who claims itself to be of international character and ready to assume international roles, ready to provide international guidance and international leadership to the global issues. And in the light of the New York declarations, sponsored, concluded two important compacts, that is the Global Compact on Refugees, then international solidarity and international responsibility sharing principles have also become the part of the international transactions. And the transactions which are discharged of a judicial character, which are discharged by the Honorable Supreme Court of India or the Supreme Court of any geopolitical entity. I also, take a cue from your observation, Mr. Sharma, that the consistency should have been met with regard to the human rights interpretations ever since the inauguration of the Constitution of India. This reminds me of a very, very important judgment delivered by the Honorable Supreme Court of India in 1994. Khudiram Chakma versus State of Assam. In that particular judgment, the Supreme Court of India has established and recognized the refugees have to be protected under Article 21 of the Constitution of India. And there should not be, when there is a question of protecting refugees, there should not be any kind of a deviation from the mandate of Article 21 of the Constitution of India. Because as per your observation, Mr. Sharma, as you have pointed out in your chat box contribution, even if it is an interlocutory order, still it has the effect of violating Article 21 and 19. Gouging for or giving the form of orders in interim umbrella is not going to change the substance, that the ultimate effect which negates all the inalienable rights guaranteed. You have also referred a 2000 decision of Chandrima Das decision. But it is very, very unfortunate, Mr. Sharma. Of late, we have been witnessing that the Honorable Supreme Court of India is not taking a robust human rights based approach with regard to the violations of citizens' rights, violations of refugees' rights, and violation of directive principles of state policies, a vision that has been enshrined in the scheme of the Constitution of India. Supreme Court of India should not operate itself within the broglio of grammatical interpretation. Supreme Court of India should not consider human rights as a national issue. Supreme Court of India should not understand with its or within its limited sufficiency so far the facts of human dignity are concerned. When we are talking of human dignity, human rights, rule of law, then these are the matters which are affecting international relations, international appropriateness, and international rule of law. Supreme Court of India cannot say or cannot espouse that if something is happening in our neighborhood or some inhospitable conditions are there in another country and people are running for their safety and taking refuge or knocking the doors of India, then it becomes very much the concern of the government of India. Concern in the sense, if we claim ourselves a civilization with a pristine beauty, a civilization that has always enriched itself with the amalgamation of different cultural streams, then it cannot run away from its responsibility. Of course, I am not advocating that the internal security and the national integrity and geopolitical integrity of Indian nation should be compromised. No. We must under all circumstances maintain our internal security. But at the same time, it is a fact that India is a might. Any refugee bloc or any chunk of people who claim themselves as refugees, they do not have the audacity and temerity to sabotage our nation state. It's a flimsy ground that on the ground of internal security, on the ground of what we call of national concerns, these refugees are not likely to get any kind of a humanitarian treatment.
So the most funny part is that, sir, they have just noted that serious allegations of internal security has been made. It is not even proved that the internal security or national security is at stake. So just because government council has said that there is a violation or problem for the internal security, court has relied upon that. So there is all disregard to the evidence and every other thing.
Well, Mr. Sharma, I was, avoiding this particular, line of argument. And thank you very much that you have basically enriched our deliberations. Because whenever the Supreme Court listened to the issues relating to or contentions relating to the Rohingya refugees, it has simply relied upon verbal submissions submitted by the Government Council. Credible evidences have not been. So my contention is, and my submission is, that India is not a soft state anymore. India is not a weak state anymore. It is not a soft power. And therefore, it is in the fitness of things that the Supreme Court of India, instead of, toeing the governmental line, it should have, given some kind of a balanced, judgment. Because there are, other issues as well. We cannot ignore the decision which you have, pointed out, that is Chandrima Das of the 2000. We cannot ignore the decision that has been provided certain important, guidance in the form of Vishakha judgment, how to implement international law within the municipal legal system. We cannot ignore Khudiram Chakma decision. We cannot ignore National Human Rights Commission versus State of Arunachal Pradesh decisions of 1996. There are a host of decisions, but the most pervading line of argument remains to be attended, and that is that there has to be a harmonious construction of the constitutional language. A golden rule of interpretation should have been there instead of a grammatical rule of interpretation. We as a nation state cannot take the plea that we are not concerned if something bad is happening in South Africa or in Pakistan or in Afghanistan. Why the government of India so worried about peace in Afghanistan? We are already having very good relations with Bangladesh. But why the government of India always making a very, very important, or is taking claims in the peace efforts in Afghanistan? Because Afghanistan is not only important for the government of India, but it is equally important for all the Central Asian republics, including Russia, America, and other important international players. So if the Supreme Court of India is having this kind of argument that we are not concerned, and the government of India is not concerned what is happening in another country, as you have highlighted in your presentation, highlighted that particular interim order or interlocutory order. So we cannot take this kind of a plea. This kind of an interpretation is a myopic interpretation. Supreme Court of India, unfortunately, I am simply having a very, very fair criticism exclusively on the basis of their, averments in writing, that it has taken a warm view of the situation. Supreme Court of India has ignored what has been the political understanding at international level, and the political understanding has been reflected in the New York Declaration of 2016 and the two important global compacts concluded under the mandate of the New York Declaration in 2018. So these, I mean, entire international scenario, or in other words, not only the political scenario, but the legal canvas of the legal scenario has not been taken into account by the Honorable Supreme Court of India while interpreting various articles relating to the fundamental rights part, and that is the part 3rd of the Constitution of India. As a whole, this should have been taken into account. Then the Supreme Court of India's stature and understanding would have been in a different light and shade. Supreme Court of India has basically, this is my understanding, well considered understanding. It does not mean I cannot amend my understanding. You can further guide me, my dear friends, but Supreme Court of India has lost an international opportunity to provide a judicial guidance to the community of nation states. I don't know what prompted Supreme Court of India to have this kind of a warm view, because the Supreme Court of India has ignored international human rights commitments and obligations which have been recognized by the government of India as well as under the constitution of the country. Number one. Number two, Supreme Court of India has ignored the emerging customary international law character of refugee protection. Number third, Supreme Court of India did not take any kind of a guidance from the well-established precedents set by itself. Number four, Supreme Court of India again ignored the idea of globalized world, constitutionalized world, and the international stature that has been attained. Number five, Supreme Court of India has strengthened a new kind of imperialism which is being spearheaded by the BRICS nations. On some other occasion, I would also be attending the last one, how the BRICS, what we call, nation states are shaping and evolving a new kind of what we call the third world notions of, of imperialism. Because if we are, matching our actions with that of the global North nation states, it means at the same time, we should not forget that we are also likely to commit the same kind of mistakes, whatever the mistakes have already been committed by the global Northern nation states. And the refugee protection happens to be one of such issues. It is a fact which has been ignored again by the Supreme Court of India that entire, refugee population, global refugee population, then out of this, population, 85% of the refugee global population is presently being hosted by the global South nation states. So repatriation, we have to locate, judicially speaking, Supreme Court of India should have located the customary international law character of repatriation of refugees, deportation of refugees, expulsion of refugees. Because the non-refoulement is not limited to the 1951 convention relating to the status of refugees. It goes beyond that. And this is a fact which has been again ignored by the Supreme Court of India. So my submission, and definitely I will continue to further evaluate, let there be the final outcome, judicial outcome of this particular decision or the contentions which have been submitted by the government of India. So in totality, we would also be having a full-fledged further deliberations. But these are the limited submissions which I have submitted for your consideration, and further we would also be once again going to attend this particular contention. Any other observation, Mr. Sultan? Are you there, Mr. Sultan Mahmood? Yeah, Mr. Sharma, anything else? Yeah. Well, my recommendation would be that, Mr. Sharma, you should also contribute a blog on these, lines, because it will definitely send a very, very important, message. And in the days ahead, you will witness a lot of, blogs, lot of bloggings on this, interim order. Because we are having two important parallel worlds. There is a world which is known as the world of citizenship, and there is another world which is known as the world of netizenship. And world of netizenship has also a well integrated part of the world of citizenship. Science and technology has strengthened the idea and understanding of human rights. Therefore, citizenship has been enriched with the idea of netizenship, or rather, the citizenship has been netizenized. And therefore, we cannot and we should not determine the province of human rights. If you recall my earlier submissions, and not only my submissions, but you have also shared those very submissions in our interactions. And in your classes of international law, you might have studied how international law is being implemented within the municipal legal system. Or in the final analysis, we can submit it that the international human rights law or the national human rights law, or whether it is the citizenship, human rights, human dignity, rule of law, due process of law, procedure established by law, and the constitutional values. These are the system, these are the values and the contours which do not recognize any kind of a geopolitical demarcation. We cannot, when there is a question of human rights or the constitutional values, we today cannot, at the beginning of the third decade of the 21st century, my dear friends, we cannot talk in terms of American exceptionalism, European exceptionalism, or Asian exceptionalism. We today have only one exceptionalism, and that is the global exceptionalism, when there is a question of human dignity and human right is concerned. Instead of expelling or deporting or repatriating refugees, we require a more scientific approach, systematic approach. Approach wedded with human rights and rule of law. It does not mean that the Rohingya refugees should be permanently hosted in India. No. They should be repatriated, provided all the requirements of the repatriation fulfilled. Because the repatriation, if at all it is going to be there, under all circumstances, it should be a voluntary repatriation. And there are requirements to determine the voluntariness of the repatriation. There is no harm in seeking international protection, international solidarity, and international, responsibility sharing. Political nature of refugee problem has always been there, and that has been the dominant, nature, and it has been recognized by the community of nation states. It is a humanitarian crisis, but with a political tinge, and that politicality of humanitarian character that has already been recognized, and therefore it is in the fitness of things that the government of India first try to evaluate, provide a full-fledged mechanism for the determination of refugee status. Refugees in India should not be treated as some kind of a marauding horde. They should be treated as human beings. A idea of temporary protection mechanism should be, in a very scientific manner, should be evolved. We should not have the multiplicity of procedures. Administrative advocacy should not govern the refugee arrivals. Rather, we should have some kind of a well-established, well-institutionalized mechanism to determine the refugee status, to regulate the refugee movement in the country or in India. A full-fledged refugee mechanism should be there. Because pushback tactics have been discouraged. And as a part of the civil society, as a part of the international civil society, as a part of the community of nation states, as one of the most important stakeholders in the world, what we call world leadership, in the process of democratization at international level, as one of the claimant of the permanent seat of the international institutions, including the United Nations Organization, Security Council, it is going to, or having these kinds of yardsticks to determine, as we have witnessed in the latest instance, that is going to weaken our claims in these international organizations. And above all, India has always been a very, very humanitarian sort of nation state. And therefore, on the humanitarian principles, if we are going to regulate the human movement or the refugee movement, there is no harm, provided we observe the norms of dignity and human rights as enshrined in international human rights instruments. Then only we can create an international stature. We can see a leadership role for the government of India as a nation state or as a Indian nation. Now I take you back to the issue which we have been deliberating, and that is statelessness. On this particular issue of statelessness, The question that comes to my mind, and that is relating to causes. What exactly are the causes when we are deliberating statelessness? People can become stateless due to a variety of reasons. Including racial discrimination, sexist nationality laws, voluntary choices, bureaucratic accidents, wrong attributions during hostilities to a particular political opinion, to a particular community, to a particular social origin people. So there is a variety of reasons. There are many other important reasons, like breakup of states into smaller countries, governments arbitrarily depriving people of their nationality. It is one of the reasons. A person voluntarily renouncing his or her nationality without acquiring another one. Meanwhile, he becomes or she becomes stateless. Then there are other reasons like marriage. Sometimes the institution of marriage, sometimes the dissolution of marriage, that also ensues statelessness. Or there may be situations, my dear friends, where statelessness automatically affects one of the spouses nationality. There may be situations where, in case of failure or inability to register children at birth, so that the child has no means of proving his or her entitlements to nationality, there may be other important reasons. Being a child of a stateless person, it may be one of the causes of statelessness. Then there have been identification in the form of discriminatory practices based on ethnicity, religion, caste, creed, race, in determining nationality status of a particular individual or a community. Religion is another important cause of statelessness. But UNHCR does not provide any kind of a specific data, as I have already submitted, because there are gaps in the collection of data by governments, by civil society institutions, by international organizations including United Nations. But there have been some statistical reporting by various institutes in many geopolitical entities, and on the basis of these estimations, impact of statelessness is generally assessed. When we talk of impact of statelessness, then the children are particularly at higher risk of statelessness, especially if their parents are of mixed national origin. Somebody has contributed. Yeah, Mr. Muhib and Mr. Asif. Mr. Muhib is of the view on interesting example which I have read it earlier about Rosa and her family in the Dominican Republic lost their nationality because a bad new law was made. They belong to an ethnic minority group and their country decided to treat that minority badly. Children who are affected by these bad laws therefore left that country, and finally become stateless. Yes, you are right. You are right, Mr. Muhib. This is one of the scenarios. And children happen to be the biggest casualty of statelessness. When their parents do not get any kind of a nationality and they are deprived of nationality protection, then they remain stateless. Sometimes, as you have pointed out, of a Dominican Republic example, even the bad laws also deprive people from nationality protection or nationality as such. These are the situations where people have been deprived, because there cannot be any kind of a substitute when there is a question of nationality. And exclusively speaking in my personal capacity, Mr. Muhib, in today's world, I am not talking of ancient era or the medieval era, when nationality was not a requirement, but in contemporary circumstances, nationality everywhere and anywhere in the world is considered to be a prerequisite to sustain as a human being, or to enjoy or to access certain important benefits. And these benefits are only available to the citizens. Then the nationality becomes very, very important. And there is no substitute of nationality. And at global level, if you conduct nationality studies, and you will find that migration as an additional ground, nationality as a ground, is going to be one of the most important contention in the Third World War, if it is going to happen. Because it is the laws relating to nationality who are going to be contested and are being contested in the present circumstances. Because in today's circumstances, no nation can claim itself as a collection of citizens of a particular origin. Even there are nation states whose native populations have been outnumbered by the experts or by the foreigners, by the immigrants. So nationality constitutes one of the most important guarantee of a relationship between the state and its citizens. It is the nationality that brings and extends a lot of benefits, including what we call sense of protection. So we cannot run away from what we call nationality, and nationality is the biggest casualty in the statelessness. Deprivation of nationality, denial of nationality, absence of nationality creates only one thing, one situation, and that is a situation of statelessness. Mr. Asif has also posed a question. Sir, I have a very bizarre question. I don't think the questions are bizarre. Questions are questions. Don't you think the notion of nation state itself is problematic? Prior to the concept of nation states, refugees problem were there. But I think earlier community were not so obsessed with the concept such as nation state. So community used to embrace fleeing persecuted people with a smile. Asif Saab, it's a spiritual question. There is no harm. It is not a utopian question. It is not a euphemistic question. Mr. Asif, you have rightly pointed out, or rather, in other words, I should say, you have recreated a scenario which is known as the refugee reception scenario. It existed in the ancient period. And that is why I can give you an example. If you go to history of medieval India, and when I am saying the medieval India, that included Pakistan, Afghanistan, Bangladesh, and entire North India, and some parts of South India, up to Vindhyachal. During the period of Delhi Sultanate, my dear friend, when Alauddin Khilji, when he killed his uncle and usurped the throne of Delhi Sultanate, then he also confronted a Mongol attack. But the Mongol attack, which was primarily divided into 4 different khanats, it was a family division. The only direction in which one of the khanats of Mongols could extend it, and that was the Indian side. And that particular period of India was occupied by the Delhi Sultanate. So they wanted to extend their empire. The Mongol Khanate was willing, one of the Mongol Khanates was willing to expand itself. The only space that was available to them, it was the northern part and some of the southern part of this particular Khanate, and in this direction it was Delhi Sultanate. So they also attacked. And one of the reasons why Mongols could not establish their roots or their what you call fates during the regime of the Delhi Sultanate, it was because of the refugee migrations and deserters. Because the Mongols persecuted each and every race, religion, and spiritual streams in this particular region of China, Central Asia, and other parts. And these people migrated, and some of them deserted Mongol army and took refuge under the reign of the Delhi Sultanate. And some of the refugees had been drafted in the army of Alauddin Khilji. And they were well versed in the war tactical or war tactics of Mongols. And they have, enriched the weaponry of the Delhi Sultanate. And they have become, these refugees and deserters have become assets for the, Alauddin Khalji. And therefore, Alauddin Khalji was able to, save Delhi Sultanate from the Mongolian attacks. And to a very great extent. It is one of the most important arguments that has also been provided, Mr. Asif. In Global Compact on Refugees and Migrants. And it is a part of, comprehensive refugee response framework, CRRF. That the political solidarity with the refugee hosting country should also be maintained, and the refugees should also be employed, and their services must be utilized in the refugee hosting state. Refugees should never be treated as a liability. And it is one of the, most important facet of the EU-Turkey deal. And if you see the EU quota system that has been designed for accommodating refugees in European nation states. So this quota system contemplated the drafting and incorporating the skills of, refugees. Refugees should not be accepted as a liability or as a burden, rather their services should be utilized. They should be treated as an additional asset of a temporary character or temporary nature. And therefore, in the today's, circumstances, the scholars have been advocating, Mr. Asif, that we must have some kind of a liberal interpretation of our nationality laws, citizenship laws, human rights laws. Because if we are claiming that we are living in a globalized world, then we should not forget, my dear friends, the globalized world must also be constitutionalized. The globalized world must be humanized. Humanization of the globalization is the prerequisite to sustain or to have a viable society. Then only we can achieve the smile which you are talking of. Then another important dimension is, and that is nationality itself. If you take into account and how nationality should be understood, my dear friends, nationality is basically, fundamentally speaking, is a legal bond between a person and a state. You're welcome, Mr. Asif. My dear friends, nationality is a form of membership that results in rights and duties. For example, right to enter and reside in the state. It is primarily a political right. Duty to perform military services. And the nationality, and there should not be any kind of a contest between nationality and citizenship. In majority of the cases, these two expressions are synonymously utilized. Because sometimes it is also argued, not necessarily, so far the nationality and citizenship is concerned, not necessarily synonymous. There is a possibility it may not be synonymously utilized. But my dear friends, both are used by different countries to describe the legal bond. And that is the most important contention between the nation state on one hand, on the other side it is the citizen. Because this bond, legal bond, binds together a state and the individual. It covers political, social, and economic rights as well as the responsibilities, both governments and the citizen. You already studied how the citizenship is granted. But when we are talking of another important dimension of stateless refugees, we are talking of stateless persons, but now I am talking of the stateless refugees. It is another important dimension of statelessness. Stateless refugees has been described a person who is not considered as a national by any state under the operation of its laws and meets the definition of a refugee in Article 1 of 1951 Refugee Convention. It means stateless refugees has to be understood, my dear friends, on the basis of the two important footings. It means we have to undertake and try to understand two important articles. Article 1 of 1951 UN Convention relating to the status of refugees. And at the same time, we have to undertake Article 1 of 1954 UN Convention on Statelessness. If you put these two definitions together, then we receive a protection mechanism designed exclusively for stateless refugees. Stateless refugees, therefore, is a person who is not considered as a national by any state under the operation of its laws, and the same person fulfills the qualifications, the mandate that has been provided under Article 1 of 1951 UN Convention relating to the status of refugees. Therefore, such persons, my dear friends, falls under the UNHCR's refugee mandate. And at the same time, such persons enjoys protection of 1951 Refugee Convention. When ceasing to be a refugee, my dear friends, such person, I mean stateless refugee, may still be stateless and need assistance to acquire a nationality. So that sort of what we call, protection is available. Statelessness, therefore, is an international concern. Because there are certain important steps, and these steps is a kind of a prerequisite to avoid statelessness. Because it is also a very, very important question how to avoid statelessness, how to minimize statelessness, how to remove statelessness. There are certain steps which must be taken into consideration before embarking a stateless free what we call world. Step number 1 takes into account we must try to understand the causes of statelessness. How we are going to understand these causes? We have to understand the golden gaps in nationality laws. We have to understand the conflicts in nationality laws. We have to understand arbitrary deprivation of nationality. We have to understand the processes relating to the state succession. as we have been, witnessing statelessness in Ukraine, statelessness in Crimea, statelessness in China, statelessness in Tibet, statelessness in some of the autonomous regions of Russian Federation. So there is no dearth of what we call of, highly advanced and civilized nation states are also, grappling with the issue of statelessness, because the process of or processes of statelessness are equally important, because common underlying factors in these processes is discrimination. Lot of discrimination is taking place. There happens to be the common contributing factors like migration, lack of what you call birth registration, administrative what you call obstacles, corruption. These are the factors which are responsible for creating or generating lot of what you call statelessness. And this is how, if we are going to appreciate on the critical footing and going to remove as a first step, so far the removal of causes is concerned, then these causes should be removed. This is the step one. There is another important step. We have to analyze under this particular step. We must try to analyze the nationality laws and practice of nationality granting. Okay, how nationality is acquired on the basis of family links. Nationality is acquired, like on the basis of parental relationships, on the basis of spousal linkages. Nationality is acquired, and there is what we call family links. After family links, there is a territorial links, like place of birth, residence. This is how we try to what we call acquire nationalities. Then under step 2, what gaps might there be in the law, nationality law? There is every possibility that we may not have or no safeguards to prevent statelessness at birth. It may be a situation. There may be a further situation like loss or renunciation of only nationality that is permitted under the law. There may be discrimination. There may be a racial discrimination. There is every possibility to have gender discrimination. There may be a situation where we find poor or no procedural guarantees. So under this particular step where we are going to analyze nationality laws, so we should try to establish good practices of granting and acquiring what we call nationality. And this is how we can minimize, we can remove statelessness. There is another important step, and that is third step, my dear friends. Under the third step, we should try to apply relevant international standards. Here is a question. When we are talking of application of relevant international standard, it means, are states free to regulate nationality? Then, in my personal understanding, my dear friends, from my side, it is a big no. Because international law now sets some limits on the freedom of states to regular access to nationality. We should create, as we have created in the area of intellectual property rights, in the area of international trade. When we are talking of trade and merchandise, what we call marks. When we are talking of the copyright law, when we are talking of the patent laws, we have adopted a number of international conventions like Rome Convention, Bern Convention, Buenos Aires Convention, and we have encapsulated, we have incorporated these international understandings provided in the area of intellectual property rights and fine-tuned. And accordingly, we have amended our national legislations. Then there is no harm in amending national, legislations in consonance with international, what we call, requirements, with international, guarantees. This is how we should try to, what we call, amend our, what we call, national legislations on nationality. And therefore, national governments must have very limited application, a limited role in regulating nationality laws, because the supremacy of the human dignity, paramountcy of human rights, an individual as a subject matter of international law must be the guiding factors in nationality laws or in regulating the nationality, if there has to be any kind of role. Because nowadays we have been, the national governments have been withdrawing from each and every field. In the name of economic liberalization, in the name of, disinvestment, in the name of privatization, in the name of, improving the services and the quality of life in each and every geopolitical entity, the governments are having the minimum, what we call, role. Even the infrastructure is being developed by the national, governments on the public-private partnership models, where even an individual, a car driver or a car owner, has also become a stakeholder and contributing for each and every time. Whenever he takes out his or her, car, he has to make some payments. Payments in the form of what we call, toll tax, for availing the good quality, roads. Because the functions, there is a sea change so far, the nature of functions which the governments today are performing. Everything happens to be at the verge of, privatization. And this is not a trend, my dear friends, in South Asia, which is taking roots. Rather, it has become an international phenomenon. And therefore, there is a, requirement. And that is why I am asking this question. What limits are set by international law on the acquisition of, nationality? Then there are, limits. Because if trade law is having a, limit, if patents have got some kind of, exceptions and limits, if copyright law is having some kind of, limitation with regard to the infringement, violations of individual rights or neighboring rights or performing, rights, novelty rights, invention related rights, then in the same way, when we are, talking nationality laws or the human rights, what we call, accessibility to human rights and the enjoyment thereof in the most, what we call, enabling environment, then definitely there is a, general principles of law. General principles of law, for example, I can say there is a, limit, and the limit is known as non-discrimination. Then non-discrimination should be the guiding factor when there is a question of, of enjoying nationality. International human rights law obligation. Nothing should be what we call, nothing should be allowed to deviate the international human rights law framework when there is a question of enjoying human rights. Then 1961 UN Convention on the Reduction of Statelessness and the fundamental principles which have been enshrined in the scheme of this particular international, obligation, that should also become the part of what we call the nationality regulations. Then, because the international human rights law contemplates as the most fundamental human right, and that is right to a nationality. Everyone has the right to a nationality. It has been ordained, my dear friends, in the most fundamental normative framework ever received by the community of nation states in the form of Article 15 of the Universal Declaration of Human Rights. So no one should be, and we should not forget, my dear friends, ICCPR, CRC, CERD Convention, CEDAW, Migrant Workers Convention, Convention on the Persons with Disabilities, American Convention on Human Rights, European Convention on Nationality, African Charter on the Rights of the people, and the Convention on the Rights of the Child in Islam. That is Arab League has adopted this particular convention. Arab nations, even at regional level, at the same time at a national level, we have been having all these conventions. Then this is the most important understanding when we are dealing with the question of mitigating as well as avoiding nationality. Now, another important question that comes to my mind: how to protect stateless people. We have to we can only protect the stateless persons by understanding the link between nationality and rights, as it has already been submitted. And once again I am making this submission just to emphasize my line of contention, and that is the legal bond between a person and a state. It means it creates a membership resulting in the rights and duties between an individual and the state, and therefore under all circumstances this legal bond must be respected. And it is the and this is something which should be understood as the traditional role of the nationality. Traditional role of the nationality is, my dear friends, the right to have rights, which has already been what we call ventilated by a French theorist. Therefore, the fate of stateless people is not a matter of what we call of charity. Rather, it is a matter of what we call right, and right to have rights is the most what we call fundamental rights. Therefore, it becomes necessary to understand, my dear friends, to understand statelessness in this kind of a perspective. There is, yeah, please.
Sorry, sir, for interrupting. Sir, I have one question.
Yeah, please.
Sir, in the past, Afghanistan had certain punishment to take Afghan citizenship from those who committed some crimes, such as crimes against national interest of Afghanistan. So, but fortunately, at present, under 2004 Constitution, such punishment are not allowed. So, sir, my question is that when such punishment are allowed in the world, or is there any human rights or refugee convention that prohibits such punishment? Or particularly, what is the situation in South Asian jurisdictions?
Yeah, what was the first part of your question? Observation. I understood your question, but before question you have said something.
Sir, Afghanistan in the past had certain punishment to take Afghan citizenship from those who committed some crimes, some sort of crimes such as crimes against national interests of Afghanistan or national betrayal.
Okay.
So,
thank you.
Yes.
In the field of international law, or in the field of law, everything cannot be determined in the name of sovereignty, in the name of nationality, in the name of citizenship, in the name of autochthony, in the name of biblical traditions, in the name of Quranic injunctions, in the name of religion, in the name of religious sanctification, in the name of the sacrosanct character of soil. These cannot be grounds of the dispensation of justice. It is immaterial whether Afghanistan claims itself to be an Islamic republic, whether it is having, because this is my understanding, that on many occasions in the past, it appeared that Afghanistan has not behaved as a republic, and it has been far from its Islamic orientation. If you study the Islamic criminal law, Islamic evidence law, and Islamic administration of justice mechanism or system, you will find, and at the same time, since you are a student of the South Asian University, justice dispensation principles which have been adumbrated in Hindu scriptures, particularly in Rig Veda, or how Buddhism has perceived the idea of justice, then you will find, my dear friend, that one of the most important fundamental principle as a right that has been recognized in all instruments, mechanisms, and manifestations is a right which is known as the right to have fair trial. And in the modern international law on human rights, and as a part of the international criminal law, as a part of the Rome Statute of 1998, where under the International Criminal Law Court has been established and came into existence, right to fair trial guarantee emerged as one of the most important fundamental right or human right. So therefore, the crimes committed by any Afghan or by any individual in South Asia or beyond South Asia, the justice system has to fulfill its international obligations in terms of procedure, in terms of appreciation of evidences on record. There are certain fundamental human rights norms. I am not simply confining my argument within the socket of mens rea or actus reus. Commission of a crime with an ill mind, that is mens rea. These are the two fundamental principles of the law of a crime to establish culpability as well as punishment. But at the same time, we should not forget that we are not living in some kind of a medievalism. And when Afghanistan is administering any kind of a punishment, it must be accountable towards its obligations to the international human rights. Because if it is not discharging its human rights obligation, then the state and its administrative structure or criminal administration of justice system happens to be in violation of its own constitution, and that constitution is the 2004 Constitution of Islamic Republic of Afghanistan, and that takes into account in one of the articles, that is Article 7, and other important articles of the Constitution of Islamic Republic of Afghanistan. Under all circumstances, no medieval kind of punishment is allowed, because what is important, even in Islamic orientation, in Hindu scriptures, in Buddhist what you call traditions, you will find that the punishment under all circumstances should be humane. If you take into account how the punishments were administered in history, then you should study the modes of punishment in history. Whether there is a English word like guillotine, in that particular instrument, a very heavy blade was installed, and it is what you call left on the top, and it cuts off, because the threshold of the pain and cruelty has to be minimized. This was contemplated by various what you call. So there happens to be in Britain a European fellow with the name Guillotine who designed this kind of a instrument, and it has been named after him. So different what you call modes of punishments. But when since we have already graduated after studying the different what you call theoretical construct of how to administer and how to grant punishments and how to punish people for various crimes, then in today's circumstances, my dear friend, we must take into account that the punishment should be dictated by rule of law, human rights, human dignity, due process of law. These are the considerations that must what you call, and the fair trial guarantee must also be ensured by the state. If any punishment happens to be in violation of these fundamental principles, then definitely that punishment is not going to be appreciated on the critical footing. And that is why idea of constitutionalism is there, and any amount of punishment which violates the contours of constitutionalism cannot be said. And in my ultimate analysis, I am totally against one of the punishment, and that is the capital punishment, because capital punishment is not going to solve the problems or minimize the what you call of commission of crimes or violations of what you call of human rights, or it is not going to serve, or it is not going to decrease the incidents of commission of crimes. It is capital punishment has already proved itself not a deterrent impact. It is not going to be. It may be a question of perceptions, because even in the past there have been Supreme Courts in South Asia where they have recorded public one of the grounds of their punishment, one of the grounds of their judicial reasoning. They have designated public perception as one of the grounds of their judicial reasoning. Anything else, brother?
Thank you. So, sir, I asked this question because in 1960s, in the Dawood Khan presidency in Afghanistan, so he announced the nullification of 80 individuals who were at that time in Pakistan. But now, under 2004 Constitution, such punishment are not allowed. So that's why I asked this question.
Yeah. Okay. Thank you. Anyway, thank you very much, my dear friends. I will continue, and I will conclude on the next, tomorrow, my remaining, submissions, and thereafter we will switch over to the next important engagement. So thank you very much for being with me. Thanks a lot.
Thank you, sir.
You're welcome, ma'am. Thank you.
Thank you, sir.
Yeah. Well, one of the observations is also there. Yeah, some.
Yes, sir.
Yeah. Yeah.
I will share it in next class.
Yeah, definitely. I will attend this one. Yeah. Thank you.
Okay, sir. Thank you.
Thank you.
Thank you, sir.
Yeah.